SJC-13491, Boston Teachers Union, Local 66 v. Boston Public Schools.
Okay, Attorney Pollard, whenever you're ready.
Thank you, Your Honors, and may it please the Court. My name is Nick Pollard, and I represent the Boston Teachers Union. The union in this matter is entitled to the confirmation of an arbitration award at issue, which required the district to hire 18 of a subcategory of paraprofessionals known as cluster paraprofessional substitutes. I'll be calling them cluster parasubs for brevity's sake. The union argues, although it is not required, to allege or prove noncompliance in order to achieve confirmation, that it does have both in the instance of this case, and that fundamentally it is only attempting to confirm an award that has not yet been complied with. The award in question, which was issued on July 28th of 2020, included a very simple command. That command was the district hire and maintain 18 cluster parasubs. It is based on a contract provision that is similarly simple, that states the district shall hire 18 cluster paraprofessional subs. The arbitrator in that award found that they had not. We argue, and we believe that there was sufficient evidence before the Superior Court to suggest that they still have not complied with that award.
Assuming we don't agree with you with respect to the ongoing dispute, tell me why Jerwin was wrongly decided.
I'm sorry?
Tell me why Jerwin was wrongly decided, the First Circuit
Ultimately, it
case.
relied on two cases that did not support the propositions for which they were cited. They attempted to use two cases to suggest that the shall unless formulation of Section 10 of Chapter 150C actually is a may if, that there is a test that there must be prospective effect to the award, which, by the way, our award does have, and that there must be no conceivable reason to not apply the award to a new dispute. The reason why that's an issue in this particular case, and the reason why Derwin should be ignored in this particular case, is that there is no such new dispute to be distinguished or not between what the award stood for and its confirmation. There is only the same dispute that the district has failed to hire and maintain 18 cluster parasubs.
It's an easy case if we think that there's an ongoing dispute. I'm trying to get you to answer the other question about in the normal course of things, if there's no dispute, right, should we have these ministerial confirmations? That's really the issue, why we took the case to decide.
And I do believe the answer is still yes, Your Honor. Fundamentally, there need not be noncompliance for confirmation to be useful. There could be, for instance, contemplated noncompliance or a history of noncompliance with a particular employer. There could be a concern that down the road this may not be complied with over an extended period of time. Noncompliance is the theme, but it doesn't necessarily have to be something that is true to fact in existence at the time of confirmation in order for confirmation to have utility.
Do we need to get there as far as whether it makes sense or not if we just stick with the plain language?
I'm sorry?
If we just stick with the plain language, we don't have to get to whether it makes sense.
Correct. The plain language, in my mind, avoids this issue in its entirety and entitles us by right to confirmation irrespective of the new dispute issue.
But so you both agree that the award is proper and there's no dispute. The arbitrator decided this and you both agree you're bound by it, right?
Correct.
So by confirming, you're confirming something you agree on.
We would...
Bear with me for a second.
I apologize.
So, right? Is that right?
That is correct.
So what we're really doing is we're shifting the form of the next fight. And that seems to be what Derwin is concerned about, is that courts are going to be now into the next, instead of the fight you're really having, which is, okay, they can't get teachers to get this 18, which may be brought back to another arbitrator. That's going to now be fought out in court. Isn't that what's sort of driving Derwin, which is, if you guys agree on things, don't come back to us.
I think that that's an accurate description of what seemed to concern the Derwin Court, but I think that this is inextricably linked to the issue of the new dispute. The concern with Derwin, and I think the mass corrections officer's case too, was concerned about a union attempting to use an arbitration award to extend that award to a new fight that would more appropriately be brought before a new arbitrator because there are new facts and new facts that need to be found, potentially new contract violations that need to be found.
But isn't that that's the nub of this that makes this a difficult case, because you're really not here to dispute what the arbitrator did. You're really here because you want an award so that you'll go back to court to fight out the next fight, right?
Well, the next fight, Your Honor, is the same fight that we had with Arbitrator Daley, which is that the district has failed to hire these folks. The only thing that's changed between now and then is the district's excuse for not hiring these folks.
Sorry, just sorry to interrupt. Can you just talk through the practicalities of the meaning of if we were to agree with you that Section 10 does allow for, and ignoring this dispute and going to Justice Kafker's question relating to how this is going to work in general, what is the practical consequence of permitting trial courts, as Section 10 seems to say, to just confirm where they're, at any point seemingly, just to confirm that this exists and reduce this to a court judgment? Can you talk about the practicalities of what that means, both in the ordinary case where there's not a new dispute, and then when there is a new dispute?
Sure. In the ordinary case where there is no new dispute, I think that there is something to be said for both sides acknowledging the finality of an issue, and it will maybe facilitate future bargaining if there remains an issue about the facilitation of that award.
But the trial court hasn't added anything new. The trial court has just entered a judgment, correct?
Understood, yes.
So how does that, what does that do in the world?
Well, when there is no dispute, it would largely do nothing.
Well, wouldn't it allow for contempt? Isn't that the whole point?
It would allow for contempt, but if there, I was answering the question under the hypothetical there being no dispute. So
sorry, I meant by no dispute, I meant no new dispute, like no dispute that arguably needs to be arbitrated. Rather, what you're contending here is, we're not talking about anything other than just wanting our 18 paras. That's all we're talking about. That's all we want. And so that obviously is the same dispute. I guess I'm asking leading questions. I think that there is a point, which is that you can get contempt at that point. And I think that they are unhappy about that, as discussed in Derwin, because there's a concern that the contempt power will be improperly used to usurp the role of arbitration in these ongoing relationships. So can you specifically address why the existence of a judgment that would exist following a Section 10 confirmation what would happen, and how I think it would help your case to explain how actually, you are not just going to go in for contempt when there's a new dispute.
Understood, Your Honor. When there is a new dispute, I think that the first thing the parties would do, and would almost have an obligation to do, because it would almost certainly involve a mandatory subject of bargaining, is bargain over the dispute. If it cannot be resolved, then, and it truly is a new issue, at which point we would file a grievance and process it to arbitration, if the issue were truly new. At that point, we would have a new decision. Either we'd prevail or we wouldn't. At that point, if we were to prevail, I don't believe we would have to go back to arbitration to relitigate the same dispute if the district were to remain in noncompliance, which I think is this very case. If, in fact, there is a new dispute, or if there is not a new dispute, then, again, I think the parties would still seek to bargain if there is, for example, a good faith effort on the district to hire folks but are simply incapable of doing so. Again, that's a mandatory subject because it involves the compliance with an existing contractual provision. So there's a bargaining obligation by the district if they're going to say, hey, we can't do this as a matter of practice. It is effectively impossible.
And what happens instead if the union goes to court and says, look, we got this, and tries to do it through contempt? What would the trial court's options be at that point?
I think the trial court then would have to essentially find facts determining to what degree the district is truly out of compliance with the award, whether or not there has been a good faith effort to make these hires, whether or not the folks...
It does shift to the court the next step. That may be right, that may be appropriate, particularly in this context, but that's the concern, right? That now instead of you going to the arbitrator, back to Joe Daly and saying, hey, they're not complying with this thing, you're going to court saying, they're in contempt.
But at a certain point, that does become necessary, Justice Kafka.
That's why you're here, right? You're not here because that's what you want. You want the courts to now be enforcing this rather than arbitration. I'm not saying you're wrong. I'm just saying that's why you're here.
Yes,
You're
and
not here to.
I think I may be being pedantic, but the shift is what lost me in the question, because I don't believe it's a shift. I believe it's exactly what Section 10 contemplates, that at a certain point, the court is going to have to find those facts. In the absence of that, we would have an Ouroboros just going back to arbitration, winning an award.
It's in collective, in your universe, there are a lot of subsequent fights over the meaning of these things. And the question is it bound by the original decision, or is it really a subject of a new arbitration?
Well,
and that's where this gets harder.
And I think actually the pleadings and the material before the Superior Court clarified that issue quite a bit. In its opposition to the union's motion for judgment on the pleadings, the district attached 2 emails, which are in the record appendix before you, that purported to list the cluster parasubs that were active in the district at the time. They numbered 13, and there were another 3 who I believe were called surround care cluster paras. So being charitable and assuming that that's the same job and that's an accurate description of each of those 16 folks, we know that they haven't hired 18.
Right, but that's the First Circuit's concern is that may not be a federal case. That may be more an arbitration matter. But again, I see your point, and the language shall says you shall confirm, because I guess the court can just say, hey, this is a subject for new arbitration, right? They can decide that, but then you're forcing the Superior Court judges to do this.
Yeah, and our concern, Your Honor, is that ultimately, especially when we're talking about hiring, a hiring cycle occurs every year. Therefore, there will be new facts, such as they are, every single year for the district to be able to trot out and say, hey, this is what we did this time, and 16 is close enough. Maybe
Think of the contempt proceedings, right? So if that's the case, you go to the Superior Court for a contempt order every year because there's non-compliance.
Well, in the event that there's non-compliance, I have to go somewhere every year, and fundamentally,
as opposed to bargaining in arbitration.
Well, we've already bargained it's a contract provision. We have it, and in order to enforce it, we're going to need a court order. Otherwise, we would be going back to arbitration every year, getting a new award because there are slightly different facts, excusing, in the district's view, the non-compliance, and we'll have a role
But
of...
you have a contempt, you have an order in your hand. That's the issue. And as Justice Kafka says, the issue here is the next fight, not this one. I'm sorry, Justice Weinland.
Can you address Article 3 of the federal Constitution, which limits the jurisdiction of federal courts like the First Circuit to cases and controversies? We don't have that in our state constitution. So it seems to me that there may be a difference between what you're seeking from the Superior Court under our statute versus what was occurring in Derwin, which where the First Circuit needed to find a case or controversy and couldn't find one.
Yes, agreed, Justice Weinland. I think that's a significant difference and perhaps explains the Derwin Court's reasoning a bit more. We don't have an issue here where if there is no active controversy, then there is no reason to be in front of a Superior Court judge. We don't have to deal with that issue, and I think that may have been something that the legislator considered when it gave such a clear mandatory demand in that statute, or command in that statute.
Okay. And is this in any way similar to a consent decree where both parties, there was a dispute, the parties have now resolved it, they go to the court with a mutually agreed consent agreement, and they ask for the court to enter it? Is there a difference between this and that?
I don't think one that's meaningful. That issue admittedly hadn't been raised below, so it's the first time I'm thinking about it, but I don't believe that there is a meaningful difference between the two.
Okay, thank you.
Can I ask one last question? Is the this circuit split still exists, right? The federal circuits, the Third Circuit goes one way, the First Circuit goes the other, the Second Circuit's more along the lines of the Third Circuit.
I believe so.
And the Supreme Court hasn't taken one of these cases, right?
That's correct. And if there are no further questions, I'd rest on my brief.
Thank you.
Thank you.
Okay, Attorney Padani.
Good morning, and may it please the court. Michael Padani on behalf of the Boston Public Schools.
Will you just explain why your client's so concerned about this issue at all? What's the big deal?
Well, I think Derwin highlights some of those issues, and I believe Justice Dorr commented on them. There's the possibility that, and in this case, we don't have to speculate, there is concern that the scope of the award is trying to be expanded to issues that were not part of the initial grievance.
Isn't that your next litigation when they try to do that? I don't understand exactly why the Superior Court can have the authority not to comply with the statutory mandate to enter the confirmation. Maybe if your client violates or is alleged to violate the arbitration award, maybe at that point, if there's an expanded use of the award, in your view, that's when you argue that. But I don't understand why at this present time the Superior Court need not comply with the statute.
Well, I would first, to your point, Justice Wendland, the statute doesn't have the mandate that the union suggests.
It does say shall.
It does,
It's
but
pretty
you
good.
can't look at the Section 10 in isolation. You have to look at it as a part of a much broader statutory scheme. And Chapter 150C, when it was enacted in 1959, it was by way of an act providing for the judicial enforcement of collective bargaining agreements to arbitrate. And as this court has previously said, in Murphy versus National Union Fire Insurance Company, dealing with Chapter 251, Section 11, it's a confirmation statute with nearly identical language, that confirmation, the purpose of confirmation is to allow a plaintiff to collect an unsatisfied award by obtaining a judgment that can be enforced.
Isn't that the purpose of enforcement?
Exactly, and that's what.
Yeah, but that's different. Enforcement and confirmation seem to be two different things. I think it's Section 13 that is about enforcement, and Section 10, which is the only thing that's at issue here, is about confirmation.
Well, so Section 10 is the mechanism that somebody would use in order to go about seeking enforcement.
Step one, right? Step one is Section 10. That's
Yes.
where we're at here. If there's some dispute about enforcement, that's Section 13, and I guess my question is, why do we have to determine that now?
Well, that would not be, that's inconsistent with the purpose of arbitration. Arbitration is intended to provide finality in a much more cost-effective and much faster manner,
Counsel-
and all we're doing is.
Sorry, absolutely, we understood the purposes of arbitration and the important role it plays, but can you address the argument that we were discussing earlier, or the situation where they've won the arbitration, the district has not hired 18 paras, maybe has hired however many, has not hired 18. What do they do then?
So I think.
Do they have to arbitrate again the same point that the district still hasn't hired 18 paras, which they already won in front of an arbitrator, or can they go to court?
It depends. If the district has flat out not complied, they have made no attempts to post any of those positions. Essentially, they've repudiated
So
the
the arbitrator's
award.
decision is subject to a good faith standard where the district doesn't actually really have to do it as long as they sort of are trying? They
No.
won, they got an arbitration that's supposed to settle this finally through an efficient means, saying the district has to hire 18. The district didn't challenge that in any
Correct.
way, shape, or form. So what does the union then do about the fact that the district has not hired 18?
The union, so I think to best illustrate what you're getting at, and this is a case, it was not referenced in the appellee's brief. It's a case out of the First Circuit that I do want to draw to the court's attention, and because I think it'll help illustrate what you're talking about in the issue that we're grappling with. It's Armco Employees Independent Federation Incorporated. It's 65F.3D as in David 492, Sixth Circuit, 1995. And so when dealing with information, a court is able to distinguish an actual failure to comply with an award, which it's empowered to remedy, from, for example, a response whose adequacy and compliance with an award is ambiguous and where the arbitrator must first make a decision. The case law is clear that the courts are not empowered to perform fact-finding or second-guessing when parties agree to resolve their conflicts.
But Counselor, I don't think, and correct me if I'm wrong, but I don't think there's any dispute that the arbitrator found the district has to hire 18 people. This strikes me as a relatively clear decision, right? It's like a number of people who have to be hired. And I don't understand the district to be arguing that it did hire 18 people, or that there's even any dispute about that. So it's pretty clear cut here. I could see that it could be not clear cut in other cases. But can you address, I appreciate I will look at the case and I appreciate the reference to it, but just as a practical matter, what is your understanding of what should happen? What should the union do when they've won the arbitration said hire 18, and they don't hire 18?
If the district has made no attempt, a flat-out failure, they can come and seek confirmation. It would be appropriate for the court to confirm the award and enter judgment in order to.
The standard,
So
whether
the-
you've made no attempt. You've
No,
got
the district has, that's the thing, so.
the standard for enforcing an arbitration agreement is not whether you've made no attempt to comply. You have to comply, right? So that can't be the answer about whether the court should intervene or not.
Well, in this particular case, the parties' collective bargaining,
Dispute for it not to be enforced, right? It has to be something different enough that you have to go back to an arbitrator for.
correct, yes, but also courts have been reluctant to confirm an award where the arbitrator is merely acknowledging or saying that the district has to comply with the provision of its contract, which is, the contract said you have to hire 18 cluster substitute paraprofessionals.
You're pushing them to go to court. We have tons of arbitration awards that we don't have these, certificates. But you're now going to force them, as soon as they do this, to go to court and get every one of these supported by an order if you keep this up, right? Because they had the right right when they got this award, right, they could immediately have gone in and done this, correct? You would have had no grounds for a Superior Court judge not to enforce this, right? If they went in right after the arbitration award, came in with this federal statute that says you shall issue this, you would have had to do it, right? The Superior Court judge would have had to do this, right? The only issue now is because time has passed, whether now it's sort of like something different.
Well, to answer your question, as far as you have to look at the statute, Section 10, again, as much part of a broader
They
scheme.
issued this award.
Yes.
When he issues that award, they have the right to go to court and get that.
For enforcement purposes, there's always, if you look at the various
They don't have
parts
the right
of
to just
Section.
get it, sir.
If you, I'm trying to, if you look at the various parts of Chapter 150C, Chapter 150C, it outlines the limited role that courts play in the arbitration process. And there's always something that triggers that. It's a party's failure to do something, a refusal. So Section 2, it outlines the circumstances where a court can issue a stay of arbitration or order parties to go arbitrate. I believe Section 4 or 5, that outlines the instances where a court can appoint an arbitrator. And Section 10 is no different. Section 10, it triggers when a party has failed to comply with an award. Either they
No, it doesn't.
No, that's 13.
Yeah.
That's a different.
Yeah,
Section
Section 10 says the court shall confirm unless there has been some dispute about the arbitration award in a specific time period. Right? So that's the trigger. Unlike the other provisions that you're saying require the court to withhold its power in some way. Section 10 specifically says you shall confirm unless your client disputes the award, seeking a modification, whatever it is. And in this case, your client didn't do it in the time period. So I don't really understand your argument that it requires a continuing dispute. I mean, isn't this like a consent decree where there was a dispute, the parties resolved it in this way through arbitration. Everybody had the opportunity to come forward and dispute the arbitration award, and time has passed, and now the Superior Court shall confirm. I don't understand the argument to the contrary. And frankly, the federal cases are all about Article 3 of the federal Constitution, which requires a case in controversy. We don't have that in our state constitution.
We don't have that in our Constitution, but this court has itself, in the Murphy versus National Union Fire Insurance Company case in 2003, it said verbatim, it is well established that courts resolve actual controversies. And dealing with the confirmation statute in Chapter 251, the court said that the purpose of confirmation is to allow a plaintiff to collect an unsatisfied award, and in that instance, it declined to confirm an award, even though it has the mandatory shall language, which suggests that there is room for the court's discretion to determine if confirmation would serve a useful purpose.
Well, isn't there a useful purpose?
In this instance, no,
Right.
because the district's position
But
is
the district has not hired the 18 paraprofessionals.
the parties' collective bargaining agreement says that the district will utilize its best efforts to implement an award.
Is that what the arbitration award says?
The award says that it will comply with that provision, but you can't, again, look at that
So
provision
you're
in
saying
a
that,
vacuum.
given that your client has actually used best efforts and just hasn't found 18 people, right?
And it would be-
So that complies with the arbitration award.
It would be for an arbitrator to decide what best efforts means in the context of hiring, because as we know, people get fired, they leave, they get promoted, so there will be times where the district will be under 18. And so is this court suggesting that anytime that happens, the union or any union would come and file a contempt action? That is not the most effective use of judicial resources.
Attorney Padani, I guess if I could, when would anyone ever get confirmation in your world of an arbitration decision?
So let's say, for example, the award required somebody to be reinstated and awarded back pay, and the district has not given that back pay. In that situation, come confirm the award, and you get that judgment that can be used if the district continues to fail to comply. Because you have to take it to its logical extreme. If you're saying that the court, no matter what, shall confirm an award as long as a application to vacate or modify was not filed within 30 days, you could conceivably have an arbitration award from 30 years ago, somebody come and seek confirmation and then try to file a contempt action, even though there's a successor agreement. And
So
it's not,
every time you dip below 18 paras through no fault of your own, you're facing contempt.
correct. And the appropriate course would be for an arbitrator to clarify the award. What does best efforts mean?
Best effort, I'm just looking at the award.
It's not in the award, it's in the other provisions.
Award is the exact opposite, right? I mean, let's just read the award. The Boston School Committee violated Article 2. To remedy this violation, the committee is ordered to prospectively comply with its contractual obligation to hire and maintain 18 cluster paraprofessionals. And then I'm reading Article 2 of the, am I reading this correctly? The school department shall hire 18 cluster building paraprofessional substitutes.
That provision was in the contract. The award is just saying comply with the contract.
So where's this good faith?
In the section, and this is in the supplemental appendix of the appellee.
The arbitrator didn't say you'll exercise good faith, right?
The arbitrator said comply with the contract, and so you look at the contract as a whole.
The contract doesn't have this wishy-washy language on Article 2 either, right?
No, it does. That's verbatim from the contract. All he's doing is
In the contract, am I misreading it? Section 15 of Article 2, the school department shall hire 18 cluster building professionals. Am I misreading that?
nope. That's the language in the contract.
So that's kind of not good faith. That's
Well-
kind of higher 18.
Higher 18, but when it comes to implementation of the award, this is in the section of the contract concerning the dispute resolution process. It says that the district will utilize its best efforts to implement an
Isn't that
award.
exactly why they are seeking a court order? Because you're trying to read in flexibility that doesn't exist. That's why they need to, and that's probably why they should have gone right up front and got the award.
Well, there needs to be flexibility because in the labor and management relationship, there will be instances where the district will be under 18 and we don't want these contempt actions. And really,
But why didn't you negotiate a provision that says the school department shall hire 18 cluster building paraprofessional substitutes to the best of its abilities, subject to the economic conditions? You know, you didn't put any of that way.
I agree, that would have been the better course here.
Well, and more importantly, within 30 days, you didn't ask for that modification
No.
to the award.
And the district is not disputing the validity or the applicability of the award. What it is saying is that confirmation here, there's not a mandatory, a statutory right to confirmation in the absence of a dispute. And in this instance,
There is a dispute. And there is even an Article 3.
Well, it's a new
There's
dispute.
an Article 3 dispute here. It's not, we don't even need to worry about whether there's a difference between us and the feds.
Well, as this court
There's a
has-
case in controversy here. You guys are fighting over whether you're complying with the award or not. And you say there's good faith language. He says there isn't, or you're not acting in good faith. I understand you would prefer this to be fought out before an arbitrator rather than a court, but I don't know.
Well, there's a material factual difference between the current dispute and the one that the arbitrator previously decided. If you look, and the union acknowledges, this is in the the transcript, index I 50 through 51. When confronted with the question about the union's true motives for confirmation, the union takes issue with, they believe a number of those cluster paraprofessional substitutes, they are being utilized as long-term substitutes. They're being misclassified in.
One other question. Is the good faith provision the collective bargaining obligation, or is that actually in the contract somewhere that your compliance with these provisions is subject to a good faith obligation? Are you supplementing that with the unfair labor practice standards?
No, the collective bargaining agreement as a whole, yes, that would be under 150E, the good faith bargaining, but
Does the collective bargaining agreement
the
have this-
implementation of an award, there's language in our contract for implementation, and it says that the committee will utilize its best efforts to implement an arbitrator's award within 30 days of its decision not to vacate or modify, something along those lines. So I would say, again,
Didn't move to vacate or modify?
no, again, we're not disputing. We've done our best to comply. At the time that the union filed the application for confirmation, the district had 16 of those positions. They were actively trying to hire the 2 others. And if the court wants to invite futile contempt actions in these situations, I
You
would,
say it would be futile.
well, so you have a.
I guess it wouldn't be good for your client, but why would it be futile?
Because the district, like I said, they are utilizing their best efforts to hire. If the district can't hire anybody, the court wants to find them in contempt when it's at no fault of their own. I mean, let's go back to during COVID. There was obviously, reservations. People hesitated to come back to work in person, particularly in a school setting. And there was it's difficult, and across the board, across the nation, there is a struggle for schools to
Maybe
fill
why
all
you
the
win
positions.
contempt.
Exactly.
You may win the contempt. You may have very good defenses to a contempt action, but they just want to get into court and say you are in contempt. They're not.
And then the court is doing what well-settled case law, including the steelworkers trilogy of cases. Courts are not empowered when parties agree to resolve their disputes through arbitration. Courts are not empowered to perform fact-finding, and
No,
that's what the
they are
union's asking
empowered
them
to
do.
enforce when you don't comply with what you agreed to do. That's different.
Understood.
Yeah.
I would just, again, I see that I'm over on my time, but
So I think we got it.
I'll rest on my briefs and thank you.